And welcome to the Chapter 12 video lecture. Now this is going to be one of the more interesting chapters because although we have studied the rules of evidence and they tell us that when evidence is particularly reliable and of certain quality, then we can give that kind of evidence to the jury without worrying about whether they are getting evidence that's not up to our standards. And so we would expect that this is quality evidence that could very well tell them the truth about what's going on. It's just, high quality stuff, whatever it may be. Now, it just happens to be, though, that in the criminal world only, not in the civil, but in the criminal world only, when evidence has been collected in violation of someone's constitutional rights in any way, the courts have decided that they will not allow that evidence to come on against a criminal defendant, not a civil defendant, but a criminal defendant. And they do that for only one very important reason. Let me explain. In the old days, before the 1960s, police would more or less routinely violate constitutional rights without really worrying about it too much. Because if they violated someone's constitutional rights, but they otherwise received good quality evidence, that evidence was going to be used against a criminal defendant. And so they didn't respect the constitutional rights of people quite as much. That being the case, in the 1960s, the Supreme Court of the United States decided that if police authorities, this is government, not individuals in the private world, but government officials, take evidence through some illegal means, that means that are in violation of the Constitution or in violation of some law, then the courts will exclude it even if it is perfectly good and very reliable evidence. That means it could mean that a murder suspect will go free as a result of a mistake done by law enforcement personnel. It can happen, has happened, and probably will happen again, unfortunately. And they do this under what's called the exclusionary rule. This was made up by the United States Supreme Court. And that's what it says is that we cannot allow law enforcement to have an incentive to violate people's constitutional rights by allowing them to use the evidence that they find in violation of their constitutional rights in a criminal case ever. And the reason, of course, is that if we did, they would have no incentive to respect the constitutional rights of people. So they use what's called the exclusionary rule to exclude evidence that was collected in violation of any constitutional rights or in violation of any law. Okay, that's what's different about all this. It's sort of like an extra, you could call it an extra evidence code in a sense, because it's only in criminal cases. And it's only where the evidence was taken in violation of the constitutional rights of the criminal defendant or in violation of some law that that law enforcement was not allowed to violate, that this rule will apply. So it's an extra evidence rule. Again, only in criminal cases, and we will apply it as necessary. So in order to understand where these violations of constitutional rights and laws can take place, we're going to go through some of the rights under the Fourth Amendment, the Fifth Amendment, possibly even the Sixth Amendment, possibly. And we'll go into the search warrant requirements, the general search and seizure rules, because the Fourth Amendment is a real big area for the exclusionary rule. If if we go too far and we take evidence that turns out to not be admissible under the constitutional constraints and the exclusionary rule, we could lose criminal cases, and we do. Same thing's true of the Fifth Amendment, which means if we let's say beat someone into a confession, that evidence is not going to come on in a criminal case, and then we'll see the reasons why. I won't go through the rest of this. Okay. All right. So let's go through some of the other areas we're going to get into. The Miranda warnings. Now, the Miranda warnings, by the way, are not constitutionally required. You know what Miranda warnings are, of course. That's when a law enforcement personnel arrests somebody takes them to the station basically. In order to get any statements out of them that they could be used in a court against them, they have to first warn them of their Miranda rights. And then that person has to agree to speak to them even after having been told their rights to not have to talk to the law enforcement. We'll see that if that Miranda warning requirement is not respected, then any statements that are made by that defendant are not going to be allowed into evidence. Same, there's Sixth Amendment issues of confrontation. That means the right to confront witnesses against you. Sixth Amendment also involves the right to counsel, fair trial, all that sort of stuff. But the Confrontation Clause is what we're going to be studying specifically to get you an idea what that does in terms of this exclusionary rule. Because it turns out if there's not proper confrontation or the right to confront witnesses against you, then that evidence that violates that obligation of allowing a criminal defendant to confront the witnesses against them, then the evidence that's adduced will be excluded. So that's the exclusionary rule. It's a cure essentially for constitutional violations. But it's more than that. There's what we call the fruit of the poisonous tree doctrine that takes the exclusionary rule and extends it out even further than the normal. So for instance, let's assume that we violate the Fourth Amendment rights of a criminal defendant by, let's say, just breaking into his house without a warrant, without any other justification, and start rummaging through all their stuff, and we find some contraband. And then we criminally prosecute them based on what we have found. Well, let's assume that not only does that happen, but when we get into the house, we find a bunch of documents. And in those documents is a receipt for a storage shed. It's not storage shed, but a storage locker in a storage facility, off-site, of course. And we say to ourselves, well, if he's got contraband here in his house, he may also have contraband in that storage facility. So let's go get a warrant for the storage facility. We probably shouldn't have broken into this house, but we can at least get a warrant for the storage facility based on all this information that we just got from breaking into this person's house. Well, we know that when you break into someone's house as a law enforcement officer without a warrant and without any other justification for going into the house, then you have violated the constitutional right, the Fourth Amendment right against unreasonable searches and seizures. Any evidence that you find in the house will be excluded. But it even goes further than that. If you find a trail to evidence through your illegal search, that trail of evidence from the illegal search, which we call the fruit of the poisonous tree, is also going to be excluded. So if what you found is the fruit of the poisonous tree, that means it came through illegal violations of people's constitutional rights, then that fruit will also be excluded. So it goes as far as necessary to exclude any trail of evidence that has come from an illegal source. So if you find it via an illegal source, it is illegal also, even if it would otherwise have been legal. So, the warrant would have been nice. That may have made it legal to get into the storage facility. But you used the illegal information that you obtained in violation of constitutional rights as support for the warrant, and therefore that warrant is also illegal, and any evidence that comes from it will be excluded. All right, so let's go to the Fourth Amendment. It's basically the provision of our United States Constitution that protects privacy rights from governmental overreaching. Now, governmental is very important. The word governmental is absolute. The reason why is because the Fourth Amendment does not apply to private citizens. It only applies to governmental agents. It means people who are working for the government. And it's basically, its general rule is that a warrant is required to search any area of privacy, generally speaking, although we'll see there's lots of exceptions to that. When a warrant is required, you have to have probable cause, which means that you have to have information that would lead a reasonable person to strongly believe or come to a strongly held belief that there is evidence of a crime in a particular location. And then, of course, it has to be based on oath and affirmation. So the person who gives the information to the court in the application for the warrant has to be under oath, so that we know that They know that they would be in serious trouble if they were to lie or to make up things. And then it has to describe the place to be searched and the things to be seized before that warrant will be legitimate or legal. All those things have to be true. And we'll see that the warrant requirement is general for most areas of privacy, but there's some exclusions based on some practicalities. And we'll also see that the warrant requirement pretty much is only going to be required for a person's residence, as we'll see when we get down to all that. Okay. All right, let's look at the exceptions to the warrant requirement. First is searches incident to an arrest. If a person is arrested, let's assume we have a traffic stop, and the traffic stop shows that the person is under the influence of alcohol to an extent where they should not be driving, and so we arrest the person. Then we can search that person incident to the arrest itself. The reasons for this is that it prevents contraband from getting into the jails. It prevents weapons from getting into the jails, and so on. And so we can search a person and whatever effects they have on their person, like in their pockets and in their briefcase, if they have a briefcase, that kind of thing. We can search those things if we have arrested them legitimately. Okay, so that is the first exception to the warrant requirement. And this is a practical requirement, or a practical exception to the requirement, because of the fact that you've got sufficient basis to arrest them, and if you do, you have sufficient basis to protect the facility that you're going to have to hold them in from contraband and from weapons. All right, next is searches of moving vehicles. If you have a vehicle that can move, I mean, I don't mean a mobile home that has been tied to the ground and is not on wheels anymore. I'm talking about something that's on wheels and can move. Then it does not require a warrant to search it. It still requires probable cause to believe that there's evidence of some crime in the vehicle, but you don't have to get a warrant in order to search the vehicle. So let's give you an example. Let's assume, again, we stop the car for someone weaving all over the road. We find that they're drunk. We say, okay. We look in the back of if you're especially at night, you'll see cops always taking their flashlight, looking in your back seats of your car. And let's assume they look in the back seat of your car and they see this, 100 pounds of cocaine sitting in the back of your car, or something that looks like cocaine. They're going to get you out of that car immediately. They're going to get in your car. They're going to look at the stuff, and basically now they've done a search of the vehicle. Or alternatively, let's assume that they have a drug dog that can sniff drugs, and they, while they're processing your stop, they bring this dog around the outside of your car, and he hits on the trunk of your vehicle and starts to alert. The dog is telling us there's drugs inside of that locked trunk of your car. Well, the fact that we have a drug dog that is trained to alert to contraband substances such as drugs is sufficient probable cause to believe that there are drugs in the locked area of your car, the locked trunk, and that because we have probable cause to believe that there are drugs in the back of your car, we can now search the back of your car without a warrant. Okay. The reason for this is because of another practical consideration. Since it's a moving vehicle, the police either get that evidence out right then and there, or it's going to be gone. All that has to happen is you just get in your car, drive away, toss the stuff out the window somewhere down the road, and it's gone. So it's not like a house where it's hard to move a house, where we can get a warrant and you can't move the stuff because it's hard to get stuff out of a house when a house is stuck to the ground. So a moving vehicle does not require a warrant, but it does require probable cause to believe that there is evidence of a crime in the vehicle. So one of the problems we had on this particular area is when we have a true mobile home, one of those that's on wheels but is parked on the street versus parked in a mobile home park. If a mobile home is parked in a mobile home park and hooked up to electricity, to gas, and cable, and is now being essentially occupied as a house, then it's not considered a moving vehicle any longer, and therefore you'd have to get a warrant because now it's somebody's residence. Now, although a motorhome can be someone's residence, even when it's on the street, if it's on the street and considered it a moving vehicle, no warrant is required. Again, if it's stationed in a mobile home park and hooked up to electricity, cable, and gas, well, then it's not a moving vehicle anymore, and a warrant is required. All right, let's look at searches of impounded vehicles. So let's assume that we have the DUI driver. We've now arrested the driver because he's weaving all over the road. He's drunker than a skunk, and now we are arresting him. Now we got this vehicle sitting out in the middle of nowhere. Well, we don't let the vehicles just sit out there for someone to vandalize. No, we will impound the vehicle. We'll get a tow truck. It'll be taken to a secured and protected facility so that it's not going to be hurt, and it's impounded. Now, of course, the owner can get it out, but they have to pay a fee for that, but they can get their vehicle back. There is a limited search that's allowed for inventorying of personal property. It is not for the purpose of finding evidence, and it does not require probable cause. If you bring in an impounded vehicle into a facility, you as a law enforcement officer are allowed to search the entire vehicle, looking for and inventorying any personal property that may be inside the vehicle. And so you would only be able to look where personal property would be located. You're not going to look inside of door panels because that's not where property is located. But you can get inside trunks, inside of an engine compartment, under the seats, anywhere where, in glove compartments for sure, anywhere where personal property might be located in order for you to inventory it. And this is done in order to protect the police against claims of theft of the property or loss of the property through some other means. Okay, so these are very limited searches. They're not for the purpose of looking for evidence of a crime, but they may end up finding it. So if you had a bunch of cocaine in your trunk, you were stupid enough to be drunk driving around with all that cocaine in your trunk, you get arrested, your vehicle is impounded, they will open that trunk to see if there's any personal property in there, and when they happen to notice there's 100 pounds of cocaine in the back of your truck or car, you're going to end up in worse trouble than a DUI. All right, so that's sort of what the impounded vehicle thing is all about. It has a limited purpose, but it can end up finding evidence of a crime anyway. All right, let's look at searches of areas in plain view. Now, essentially what this means is that anywhere that a police officer is allowed to be by law, where that officer can see something in plain view, it means just by looking at it, even if that requires, let's say, some binoculars, that if they can see it in plain view from wherever they legally may be, then that's a search. Essentially, you're looking into an area. Well, if the officer can do so from an area they're allowed to be, then there is no requirement for probable cause. They can search all they want. Let me give you an example. Let's assume that someone says, well, my neighbor's been growing marijuana in his backyard, and I think it's against the law, and I'd like you to go look. So the neighbor says, come on in my backyard. So this is the neighbor asking the police to come into his backyard. So the police go into the neighbor's backyard and look over the fence into this house that presumably has marijuana growing in the backyard. While the police officer's at the fence line, the police officer is allowed to be there because the neighbor allowed the police officer to go into his backyard. So he's legally allowed to be there. He looks over the fence. He sees marijuana growing in the yard next door. Then that is a search of the backyard of this person, presumably who had marijuana growing in their backyard. That's actually a search. They're searching by looking, and that's what a search is you go look around for stuff. And so a search has been performed, and if it's in plain view where an officer may be allowed to be, then it's a search that's legal, absolutely legal, because it's just where the officer happens to look around where he happens to be. And another good example, this is when we stop a vehicle legally, let's say just for even a taillight being out. The officer looks in the back seat through the window and sees ammunition on the floor. Well, that's a search, especially if they use their flashlight and it's at night. They're definitely searching. Perfectly okay, perfectly legal. It is a search, but it's of an area that's in plain view of the officer where the officer may legally be. and he legally could stop the vehicle and could legally, confront the driver about the violation, and so could legally be right next to the driver's window, and then look through it to see the back seat. Not a problem. All right, let's look at searches of abandoned property. Now, this is there's lots of examples of this. A good one is your trash. I'm not sure if you know this, but if you put your trash out on the street, it's considered abandoned property. That means you don't want it anymore. Of course, that's true in most cases, but the problem is that sometimes what you have in your trash is some very sensitive stuff. You maybe not realize it, but it could get you in some serious criminal trouble if it's, let's say, a bunch of notes about your, cocaine sales that you don't want the police to have. So you throw them in the trash. If they pick up your trash and go through it and find, the evidence, well, then they can have it because it's abandoned property. These things have also been seen where police officers might chase somebody. They may order a person to stop because maybe they have at least sufficient cause to order them to be detained, at least temporarily. And the person, instead of actually stopping, they run away. And the cop, of course, chases them. And this is typically done in a drugs situation where they've got a bag of drugs on them. And so as they're running away, they will throw the bag to the side as they run away. Well, the cop then will pick up this bag of cocaine, let's say, that's been thrown away by the running suspect. And that's abandoned property. They gave it up voluntarily. They didn't want it anymore, of course. So it's abandoned property. It does not require probable cause. It's a search. We're looking through this stuff. We're testing it. It's all being searched by the police. Perfectly okay. Does not need a warrant. That's another example of exceptions to the warrant requirement. All right. Here's another one. And this is searches without probable cause when the police have reasonable suspicion that the crime is occurring or is about to occur. This is what we call the stop and frisk or the pat-down search. And what typically happens here is that something's going on in front of the officer, and the officers, based on patterns of behavior that they've seen before, they don't have probable cause to believe that someone has committed a crime, but they sure have a reasonable suspicion, something less than probable cause, but more than just nothing. Let me give you an example. A cop is driving down a residential street at 2 in the morning. He sees two suspects jump over a backyard fence onto the sidewalk and start running. These suspects are running away from the officer as the officer is approaching in his vehicle. Well, we don't know for sure, or even have probable cause to believe that they burglarized that house where they came out of the backyard of, but we certainly have reasonable suspicion that based on the time of day this is happening and the unusual circumstance of both jumping over the fence and, most importantly, running away from the officers, that there's reasonable suspicion to believe that a crime is occurring or is about to occur, and therefore the officer has a right to stop the suspect. That means to detain them, not to arrest them because they don't have probable cause yet, but they can detain them for investigative purposes for a very limited time. So you have a limited stop justified by this reasonable suspicion, something less than probable cause. Now, if at the time we stop these people, they give us some reasonable suspicion to believe they may have weapons on them, such as we tell them to take their hands out of their pocket and they refuse to do that, then we can immediately pat them down for weapons. That means we pat down the outside of their clothing and see if we can feel something that is consistent with a weapon. If we can feel something consistent with a weapon, then we can dip into the pocket and grab it. And that's for the protection of the officer, based on the fact that they're now in a very precarious position because they've got, sometimes you have more suspects than they have officers. And in any event, when you have certainly one or more suspects who want to get away, they may end up hurting the officer or killing the officer trying to get away. So this is justified, and it's called the stop and frisk. The stop is the detention. The frisk is the pat down for weapons. Now, if we pat down someone for weapons and we can't feel something that is consistent with a weapon, such as a knife or a gun, we cannot get into their pockets and see what it is. Okay, there are some limited exceptions to that, but we don't have to get into those for right now, because since this is not a course on search and seizure law. But Certainly, you can't get in the pocket unless you can say, based on this feel, I feel a gun in there, or I feel a knife, or I feel something that's at least consistent with a knife or something consistent with a gun. You can't dip into the pocket and get it out. All right, so searches, that's the searches without probable cause, but where there's reasonable suspicion to believe that a crime is occurring or is about to occur. All right, there's also searches without probable cause at international borders. Now, it happens to be that uh, this is based on practicalities also. You come through the borders of the United States, you will be searched. It's very much like going through an airport. You're going to be searched, and the reason why is because it's just been found to be sufficiently justified because of the tremendous risk of people, let's say, bringing things across the border. They shouldn't. Or for airports, bringing on weapons to kill people in airplanes or bring down the airplane. Now, what you have to remember about all these exceptions to the warrant requirement is these were all created by the United States Supreme Court when they interpreted the Fourth Amendment that prohibits unreasonable searches and seizures. The words unreasonable searches and seizures, it was a very broad standard. What's reasonable? Well, courts had to decide what was reasonable in any given situation. And so over the last 100 years or so, they've had a number of decisions that have, to a large extent, sort of filled in this area of what's reasonable and what's not in the area of law enforcement searches and seizures. And so all these exceptions to the warrant requirement have been essentially created by the United States Supreme Court out of this idea that reasonable searches and seizures has to do with balancing the right to privacy versus the right to protection against crime. And so they're always weighing this need for protection versus the need for privacy. And they have just decided over many years what police can do and what they cannot do in connection with searches and seizures. Okay. All right, let's look at searches of occupants at a place where a search warrant is executed. Let's assume we do a drug warrant at somebody's house. It's a perfectly good warrant. We have probable cause to believe there was drugs in the house. We break into the house typically. We take everyone who's in the house and we set them down on a couch. We usually put them in handcuffs because we don't want to get hurt. And so we basically incapacitate them for a period of time until we do our search. Well, we can also search the occupants themselves. Whoever's in that house, we can search them. And the reason for that is the protection of the officers, because they're in a very precarious position. They've got people who are in the house who may not want the officers to find out what's going on, and may want to leave when they're not yet, shouldn't be able to leave because they may be someone involved in the crime because they happen to be there. They may or may not, but at the very least, it's possible that someone there may know that if a search is going to be performed, that they're going to go to prison for a very long time. And that being the case, they may want to hurt the officers or kill the officers in order to stop that from happening. And because of that great risk that officers have to bear, the United States Supreme Court has decided that if you're an occupant of a place that happens to have a search warrant executed on it, then you're going to be searched. And it's not because we're looking for evidence. It's to protect the officers so that you don't have any weapons that you could use against them. And that's the only reason for it. But you can be searched as to everything you have around you or on your person. You can be searched. Okay, and that's, again, just for protection of the officers. All right, let's look at searches under exigent circumstances. Exigent just means something that's kind of out of the ordinary and something very, very urgent. So under urgent circumstances, such as a threatened destruction of the evidence, escape of a suspect, or hot pursuit of a fleeing suspect, then searches can be performed. So let's just assume for the moment we have a felon who's just robbed a bank, or we have more than probable cause to believe that the person robbed the bank because maybe we watched it going on and then we ran after the person who just robbed this convenience store. And as we're running down the street, this guy just checks right into somebody's front door and runs in the house. Well, you think, well, we got a house now. We have to get a warrant to get inside the house. No. You have a hot pursuit of a fleeing suspect. You can run right into that house and get him. And if you have to search the house to find him, because he's hiding in the house somewhere, you can search the house solely for finding that suspect. You can do that. Another good one is sometimes, and it's not a good idea, but they will do it. Let's assume we find someone we think who's selling drugs. Let's say heroin, very, very typical. Well, for some reason, they put heroin inside balloons. They do that probably a lot of reasons why, but one of the reasons is just so that in case the cops come up and try to arrest them, and they don't want the heroin to be found, they're going to put these balloons in their mouth and swallow them. So they think that they're going to destroy the evidence by swallowing it. Well, if someone's trying to swallow something under those circumstances, and you've just watched them do hand-to-hand sales of something that looks like drugs, then that's what we call an exigent circumstance. This is an immediate threat and destruction of evidence. You can grab those things right out of their hand and seize them. You can search their mouth for them. You can search wherever they may have put them. And that's because of this exigent circumstance. It's going to be destroyed. If you don't get your hands on it like right now, it's going to be destroyed. And so that's an exigent circumstance where you can now search. This could also go into something like where we have pretty good evidence to believe that someone has a bomb in their house, for instance. Normally you have a warrant requirement. You have to get a warrant to go into somebody's house, and that is definite for residents anyway. But under these exigent circumstances, because there's a bomb threat, a real bomb threat in that person's house, it would allow officers to go in there and find it immediately rather than let it blow up. So that's an exigent circumstance. But it better be really an emergency situation. It can't just be someone says there's a bomb in someone's house. It has to be, you have to have pretty good evidence that there is a bomb in someone's house to use this exigent circumstance to go in and get it. All right, searches in places where there is no reasonable expectation of privacy, such as a prison or jail. Well, you probably heard that prisons and jails have, their walls have ears. Well, that's quite true. They do. They actually do. They actually have listening devices pretty much everywhere. In fact, the only place where they don't is in the interview rooms where the attorneys come in and talk to their clients. So if you say something anywhere in a jail or a prison, even if you're an employee, it is capable of and will be recorded. They can hear anything. And police will sometimes send in to the jail someone who has been dressed up to look like a criminal suspect who's actually a police officer to go in and just listen to what's being said in the jail cells. And if they can hear it, it's a search, but it is in an area where there is no reasonable expectation of privacy, and so you're not going to have any privacy. It's going to be used against you. Your telephone calls from prisons or jails are also recorded and can be used against you without even having to justify that invasion of privacy, because there is no privacy. The courts have made it very clear. Any prisons or jails are absolutely areas of no privacy whatsoever, and the only exception to that is in areas where attorneys will interview their clients. And that's because of the attorney-client privilege, and otherwise there is none. All right, let's look at the exclusionary rule itself. This was actually created in the 1960s, along with many rulings that were coming down that prohibited police from violating people's constitutional rights. And they just basically decided that the only way we're going to stop police from violating people's constitutional rights is to make it so that they can't use the evidence that they find in violation of those constitutional rights in a court, in a criminal court, that is, against that person. Nothing prohibits it from being used in a civil court, by the way, but in a criminal court, no. And so, remember, it has to be government taking of evidence in violation of a person's constitutional rights that will require the exclusion of that evidence in a criminal case only. And then the fruit of the poisonous tree doctrine, which we've already gone over, but it is the same thing, except that if the evidence comes from or is derived from existing illegal evidence, then it's fruit of the poisonous tree, and it will be excluded also. So any trail of evidence that comes from illegal evidence will be excluded also. So if you could destroy an entire investigation, by the way, by starting out with an illegally seized bit of evidence, and if that ends up leading to more evidence, then you're going to end up having the whole case being destroyed because none of the evidence can be used in a criminal court. Okay, that's what the exclusionary rule is, and the fruit of the poisonous tree doctrine. There are some exceptions to the exclusionary rule, and we have to think first as to why we're using the exclusionary rule to see what these exceptions really are. But again, the exclusionary rule was there to prevent police from willfully violating people's constitutional rights, which they were doing prior to the 1960s with impunity. And that's the whole purpose of it. And so if the purpose of the exclusionary rule is no longer being manifest, then we won't use it. Let me give you an example. The first one is the good faith exception. Best way to give you what the good faith exception is to give you some of the more classic cases of it so you understand. But let's assume that a police officer has collected lots of information and wants to use that information to get a warrant, to get into somebody's house, to break up a big drug ring in a city. Okay, they get lots of information, and they get a whole bunch of it, and they think, wow, this looks like probable cause to me. I think there's more than sufficient evidence here to believe that there is probable cause to know that there is evidence of drug sales going on in that house. Well, not only does the officer think that there's more than sufficient probable cause, but the officer then goes to the public prosecutor and says, I want you to look at this warrant. Tell me whether you think there's sufficient probable cause to believe that we should get this warrant. And the prosecutor says, oh yeah, you got plenty of probable cause here, no problem. You know, go get the warrant. And so then the officer goes to the magistrate, this is the judge, and says, okay, here's my application for the warrant, here's all my evidence. I think I got probable cause, will you issue a warrant? Magistrate says, oh yeah, you got plenty of probable cause. I'm going to issue this warrant. Magistrate issues the warrant, the officer goes into the house, finds all the evidence. The person's arrested in the house, criminally prosecuted for the drug sales and so on. And then in court, when you go to in front of another judge who looks at the same warrant, that judge may say, you know what, I disagree with the magistrate. I think there was not probable cause for this warrant to be issued, and therefore I'm going to find that the warrant is invalid. And because the warrant is invalid, you just broke into somebody's house without a warrant, at least not with a valid warrant, and so I'm going to exclude the evidence. Well, it sounds like that's a bit much because, you know, here's an officer in good faith doing everything possible to make sure that he or she is doing exactly what they're supposed to do. And the system basically didn't do well by the officer by, you know, sort of, on the one hand, giving them a warrant, and on the other hand, taking it away. You know, exactly how are you going to make an officer do any better in terms of trying to protect someone's rights than what the officer did? Well, the answer is there isn't anything else the officer could have done. That's the best that you could ever expect from any officer. And therefore, when something like that happens and the good faith of the officer is established in that way, then we're going to not use the exclusionary rule. We're going to allow the evidence to come on, even if otherwise it's invalid in the sense that it's illegal evidence. And the reason is because the exclusionary rule is not going to do what it's supposed to do. It's not going to make the officers more cautious about protecting people's constitutional rights because they've already done that. So that's the good faith exception. That happens in cases where, you know, the officer couldn't have done any better. He couldn't have asked for anything more. And if that's the case, then the exclusionary rule will not be used. Next one is inevitable discovery doctrine. So let's assume that we beat someone into a confession about a murder case. Let's say a child was murdered. We don't know where the body is, but we know they were murdered, and we got the guy we think did it. He's in custody. We sort of beat him into a confession. Tell us where the body is. So he tells us where the body is. We go look. Sure enough, that's where the body is. We recover the body. Well, that's illegally obtained evidence. You're not going to be able to use the discovery of the body because it's illegally obtained through, you know, beating someone into a confession, which we'll go through here in just a minute. Here, you can't beat people into confessions and have the confession or any evidence that leads from the confession to be used in a court. But let's assume also that we had a troop of explorer scouts out looking in the forest where we found the child's body. and it would have been only a period of about a half a day before they would have just come across it anyway, based on what we had already set up to happen. So we already know where they were going to go. We knew we already had a plan for them to go out to specific areas and look, and they would have discovered it anyway. Well, then if it was in fact inevitable that the police would have discovered the evidence anyway, then of course the exclusionary rule is no longer of any value, and so it's not going to prevent that which would have come on as evidence anyway, and therefore it's not used. Even though it may have been illegally obtained, we're still not going to use the exclusionary rule to exclude it. Okay, so that's the exclusionary rule exception for inevitable discovery. Next is the attenuation doctrine. Where this happens is where, yes, technically speaking, the evidence did in fact trail off from some illegally obtained evidence, such as, let's assume we get a confession from a person after an illegal arrest. Now, the officers, may not have realized it, but their arrest was illegal. They didn't have sufficient probable cause. They get a confession from the person. Well, yes, the confession came from the illegal arrest because they wouldn't have had the person in jail in the first place to even talk to them if it wasn't for the illegal arrest. But probably that's so sufficiently removed from the illegality that it's really not, one doesn't really lead so much to the other. In essence, it's just so far away that somewhere along the line we're not going to use the exclusionary rule any longer, even if technically speaking one thing had to have led to the other. In essence, we have illegal conduct that it did in fact lead to certain evidence that we discovered. If it's sufficiently attenuated, that means it's far enough down the road, then we will often allow it in because it's just it's no longer something that is direct evidence. It's sort of indirectly from the illegal evidence. Okay, so let's say you have an illegal arrest, and you find on a search of the person, you find a storage receipt for a storage locker, and then you go to get a warrant for the storage locker. Well, yeah, that's pretty attenuated. That's pretty attenuated because although it's direct, it's not direct. It's actually indirect. You indirectly found the stuff in the storage facility based on the illegal arrest and search of the person. They're just getting too far apart. So when they're too far apart, we no longer use the exclusionary rule. All right, let's look at the independent source doctrine. When evidence is obtained from a source independent of the illegal obtained evidence, it is not excluded. So what you could do, let's say, is say, okay, we found some stuff. It's fruit of the poisonous tree, but then you do an independent investigation that's based entirely on the legally obtained evidence, and it finds the same evidence that was found illegally, then you're good. Then you are good because you have an independent source. So once you have that independent source, then the independent source justifies the use of the evidence because it's no longer coming from an illegal source. Even though at one point it came from an illegal source, it also came from a legal source. So if it can come from a legal source, you're going to get it in one way or another. So why? Because you did it right, and you found the same evidence. Good. That's fine. You can always bring it in if you found it through legal means. All right. So let's look at the Fifth Amendment. That was all Fourth Amendment stuff so far. Now let's look at the Fifth Amendment. It basically says no person shall be compelled in any criminal case to be a witness against himself. This was actually a reaction to the British, who used to beat people into confessions as a way to solve their criminal cases. It's a pretty easy way to solve your criminal cases. Let's just go find the usual suspects, beat one of them into a confession, and you've got yourself a case, and you win. It may not be the person who did it, but who cares? It's that kind of an idea. And because of that was going on, we put it into our Constitution that the government will never do that against us, ever. We cannot be compelled. And that's been extended out to even psychological compulsion, meaning you psychologically psych someone into confessing to a crime, improperly. That's also a violation of the Fifth Amendment, as we'll see. Now, self-incrimination means information such as statements and documents provided by an individual that can implicate or inculpate them in criminal conduct. So usually it's statements. Documents will not be under the Fifth Amendment, because if you write something down and we legally find it, we can use that against you. But we cannot make you say something. We cannot make you testify against yourself or make statements against yourself. You can simply tell the police, I'm not going to talk to you. Why? Because you have a right against self-incrimination, whether you're in custody or not. All right, so the Fifth Amendment right was also being abused by police routinely back before the 1960 rulings. And it was in the 1960s that the Miranda case came down. That's Arizona versus Miranda. And the United States Supreme Court decided that they sort of had enough of police beating people into confession, because that's what they were doing. They would literally, they didn't necessarily have to beat them, but they would make them so uncomfortable that if they didn't confess, they were going to be tortured, essentially, one way or another, either psychologically, possibly physically, or both. And it was just easier for them at some point along the line. If you want to get some sleep, I'll tell you what, you better confess to this crime, because otherwise we're going to have you up here forever. You're going to be up, and you're going to be without sleep for the next 2 weeks, that kind of thing. And so because the courts had had enough of that, they decided, well, we've got to find a way to stop police from rounding up the usual suspects, beating somebody into a confession, and solving crime that way. That's not how we should be solving crime. We should solve crime by going out and finding good, reliable, and legal evidence to convict people, and that's the end of it. So we wanted to find a way to sort of remind people that when they're in custody of police officers, they don't have to talk to them. They can remain silent. Because if we remind them that they can remain silent and then they otherwise decide they want to confess, then we're okay with that. Nothing wrong with someone confessing to a crime if that's what they want to do. But we don't want them to do so because the police are pressuring them or beating them into a confession. And based on that, then we had this Arizona versus Miranda case, and the court just said, okay, you know what? This is the way it is. If a suspect is in custody, then the police may not use any statements from an interrogation of the suspect until advising the suspect of his Miranda rights, and the suspect thereafter agrees to speak to the police. Now, two things are important there. First is they have to be in custody, and it has to be interrogation. In custody is a bit sometimes ambiguous, because there's the classic, you're in custody when you got handcuffs on, you're in the back of a police car, and you're on your way to the station. That's in custody, no doubt. But there are cases where there have been what we call constructive custody. That means that although the police say, I didn't have him under arrest, I was only detaining him, but I had handcuffs on him because I thought he was a danger to me. Well, sorry, if you put handcuffs on someone, then it's constructive arrest. The reason why is because that person believes they're under arrest. And that's why they're under a lot of pressure. They think they're under arrest, and therefore the psychological pressures that come in to play are those that we want to protect against. And so they made up this idea of constructive custody. But in any event, if the traditional ideas of custody are there, you point a gun at someone and tell them to get on the ground, they're in custody. You put handcuffs on them, you put them in the back of a police car, they're in custody, even if you never meant to actually arrest them as a police officer. Next is interrogation. That means you have to ask them something. You have to solicit from them a response. You have to do something that would solicit a response. So if you happen to have somebody in custody and they're at the booking desk, and you say, okay, what do you have in your pockets? Who's your next of kin? And you start, those kind of questions. That's basically just to get information about the person. That's not considered interrogation, because you're not asking for evidence of a crime. And normally speaking, you might sometimes you'll see people who are police officers, and they're driving someone from the station to the county jail. And they'll sometimes have a little bit of small talk. What are you in for? What'd they get you for? Or, small talk. Nothing meant to actually ask them about their crime. And they're just talking. as two people might talk because it's better to talk rather than, sit in silence. And so they're not asking them questions. They're not asking questions certainly about the case. But all of a sudden this person has to say something that we want to use against them. Then the answer is yes, we can use it because it's not interrogation. Interrogation is we're asking them questions about the crime. We want to know about the crime. So that's what interrogation is. All right, so we have to be in custody, and it has to be interrogation. So, of course, you probably have heard the Miranda rights many times by just listening on television. You have the right to remain silent. Anything you can and will, anything you say can and will be used against you in a court of law. You have the right to presence of an attorney during questioning. If you can't afford an attorney, one will be appointed for you. With those rights in mind, do you want to speak to us? If they just simply start speaking, that's a yes. If they say yes, I want to talk to you, fine. If they say no, then you can't ask any more questions. If you do, anything you ask after someone says, I don't want to talk to you, then you can't use whatever they say, ever. Not because it'd be in violation of the Miranda warning. Okay? Also, there's a public safety exception that's not required where the officers of the public safety is in jeopardy, and the questioning relates to that safety. So if we think someone's got a bomb in their house, and we're asking them, where's the bomb? How is it put together? What do we need to do to defuse it? We're asking those kind of questions. Now, those might be considered also interrogation, and they truly are. But here's an exception, because when public safety is at issue, we don't care anymore about Miranda rights. And so we can ask those questions. And yes, whatever responses we get can be used against that person. Yes. Why? Because there's a very legitimate reason for asking those questions. All right. There's also an undercover interrogation exception. It's not required when the suspect does not know that the person they are talking to is a police officer. So you send in an undercover, either criminal or undercover officer, because if you send in a criminal to a jail, for instance, you put them in the same cell as one of these criminal suspects that you have, and they're going to be told not to ask any questions about the crime, but just to talk to the person, say hello, and be the typical criminal that you are, and see if you can get them to tell you something about the crime. Then that's perfectly okay, as long as you don't ask them questions about the crime. You just talk to them like a normal person, and then let them decide to tell you about the crime. Then too bad. Even if you don't know it's an undercover officer or an undercover criminal, it's actually a criminal, but undercover acting as an agent for law enforcement, then that's perfectly all right. Also, routine booking questions is another exception. When we ask you what's your name, where do you live, who do you want to call in the event of emergency, what's your birth date, what's your place of birth, all this other stuff we typically have in routine booking questions. That's an exception. Even if we use the fact that you say you live at the very place we just searched via search warrant, we can use your statement that you live there against you, even if it's just because it's a routine booking question. And so it's actually an exception that can sometimes be more than the courts may have wanted, but they have to make these exceptions basically what we call bright line rules. If it's a routine booking question, then it's not considered interrogation for Miranda warning purposes. All right, so the exclusionary rule applies to statements made in violation of Miranda. That means if there's a violation of Miranda, that means that the person either wasn't warned first about their Miranda rights and they're in custody and they are interrogated, then the exclusionary rule will apply to stop any statements from coming in after they were in custody and after they were interrogated. Or let's assume they were given their Miranda warnings, but they said they don't want to talk to you, and yet you ask questions about the crime anyway. Excluded, because it's a violation of the Miranda warnings. Okay, let's look at the Sixth Amendment. It provides a part that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. This language is referred to as the Confrontation Clause. You have a right to confront the witnesses against you. It's one of your Sixth Amendment rights, and that's of course because we if you can confront these people, you might be able to show the jury that they are not telling the truth. Because they're not telling the truth. Okay. All right. So the Sixth Amendment has been used in a way specifically for the hearsay exceptions that we've studied. Some of the hearsay exceptions have been found to violate the Sixth Amendment right to confrontation. Why? Because the person may never be able to be put on the stand for us to confront and cross-examine. Certainly a dying declaration is a hearsay exception, right? So the person's dying and they tell us the circumstances under which they were killed. Of course, they have to know that they are dying, and if they do, then their statements come on as evidence, even though we can't cross-examine them because they're dead. Okay, well, that's would be, you'd think that's a violation of the right to confront. Well, it is actually, but it turns out that the courts have decided that some, but not all, of the hearsay exceptions are going to be invalidated in criminal cases only under the Sixth Amendment, because they do, in fact, violate this right to confront and cross-examine its witnesses against the criminal defendant. Not all of the hearsay exceptions, just some of them. And it's actually was brought out in a case called Crawford. It was a Crawford case, and so we call it Crawford evidence. If we have Crawford evidence, it's going to be excluded in a criminal case. And so it takes a bit of an explanation here, because this is only in a criminal case. Stuff that would come on because it's an exception to the hearsay rule will be excluded, even if it's otherwise reliable evidence under the evidence code. It's going to be excluded in a criminal case because of this problem of it violating the Sixth Amendment right to confront and cross-examine witnesses. So we're going to go over when we have Crawford evidence as opposed to not having Crawford evidence. If we have Crawford evidence and we have a criminal prosecution, then the Crawford evidence will be excluded, even if otherwise it's perfectly good under the hearsay exception that we've seen so often work to allow evidence to come on and the jury to see it. Okay, that's kind of important. So again, if it's Crawford evidence, it's going to be excluded. If it's not Crawford evidence, it's not going to be excluded. All right, so let's get into the specifics. Crawford evidence. If your case is criminal, then we have to determine whether the exception to the hearsay rule is what we call testimonial in nature or not. That's U.S. versus Crawford. If it is testimonial in nature, it is not going to be allowed to come on at all. So because now what we're dealing with here, when we're dealing with the hearsay exceptions, we're dealing with statements that were made outside of court that are now allowed into court for the truth of the matter stated. Remember that hearsay is out-of-court statements brought in to prove the truth of the matter stated. And so if we have an exception to the hearsay rule that allows that hearsay to come in, then we are allowing in an out-of-court statement to prove the truth about what was said, and that just sets up the possibility that we might not be able to cross-examine that person. Why? Because we've seen situations where we could have a person who has never been identified, but who said something at the scene of an accident about how the accident happened. Under the right circumstances, that statement can come on to prove how the accident happened, even though we never can even know who that person was. So, for example, there's a crowd of people on a street corner, and one of the people apparently must have seen this car coming down the road and running a stop sign, and then coming in and slamming into a car in the intersection right in front of them. Now, maybe only one person actually saw that this car that comes careening through the intersection was, in fact, previously one that ran a red light just before in the previous block. But everyone at the corner saw the collision actually happening right in front of them. Well, maybe that one person happens to say out loud, "Oh my gosh, that car just ran a red light and smashed into this car." And maybe it's even an excited statement, indicating an excited utterance. Well, we know that that statement can come on to prove the truth of the matter asserted as to how the accident happened, even though we can never identify who that person was. Okay? The question is whether it's testimonial in nature or not. So let's look at what that means. All right, statements are not testimonial. That means they are admissible when made in the course of police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police to assist to meeting an ongoing emergency. Okay, and what that means is if the statements are coming because police are asking people questions, then if the purpose of the interrogation by police is primarily to enable the police to meet an ongoing emergency, then we consider the statements to be non-testimonial because we're right in the middle of an emergency situation. You wonder, why would that be non-testimonial? Well, the reason why is because if police know they're in the middle of an emergency situation, then everyone else around them also knows they're in an emergency situation. And because of the reliability that goes on when people are in the middle of an emergency situation, they don't have time to be making up statements. They're there to let the police know whatever they can to get that emergency under control. And so not only is there no reason for them to lie and every reason to tell the truth, they even don't have the time to make up a lie. And for that reason, we consider those non-testimonial. However, if the statements are testimonial and excluded when the circumstances objectively indicate that there was no such ongoing emergency and that the primary purpose of the interrogation is to establish or prove past events potentially relevant to some later criminal prosecution. Let me give you an example. Let's assume that police come up to a house after a call of domestic violence. The call says, hubby's there beating up on his wife. Wife's on the phone, by the way, calling 911. Cops are getting there as fast as they can. As soon as they get there, the wife's coming down the stairs from the front door, meeting police. She's crying, she's sobbing, she's obviously, she's got, let's say, she's bleeding, she's missing a couple teeth. Cops ask her, what happened? And she says, my husband beat me. Okay, where is your husband right now? He just took off in our car. What's the description of the car? It's a such and such kind of vehicle. It's got the license plate such and such. Okay. The statements we just got so far are what we call non-testimonial. They were made from police interrogation, but under circumstances objectively indicating that the primary purpose of the interrogation was to enable the police to meet an ongoing emergency. We've got someone out there in the world who was just beat up on a woman in a felony way, probably, based on the damage we've seen so far. We got to catch that person before they do something bad to themselves or others, and we got to catch them. So that's why we're asking what happened, where's hubby, what kind of car is it? Now let's say that the police who take that statement send one of their officers out to catch hubby, but they also sit down with the wife, calm her down, get her to where she's not crying anymore, get the EMTs to sort of fix her up a little bit so she's not in any gigantic amount of pain. She starts to settle down quite a bit, and then they start asking her what happened. And she starts to say, well, we had this argument, and he went crazy, started beating on me, started beating up on the children, and then I called 911 as fast as I could. Next thing I know, he hears your sirens and he's out the door. Okay, that's testimonial. Why? Because now our purpose really is to establish the criminal case against hubby, not to try to find hubby or to arrest hubby or to get control of an emergency situation. It's to get hubby convicted. Okay, and that's the difference between testimonial and non-testimonial. So whenever you see a hearsay exception where you have police interrogation going on, police are asking questions, you got to then figure out whether you've got Crawford evidence or non-Crawford evidence, whether you have non-testimonial or testimonial evidence. And if you have testimonial evidence, you're going to have to exclude it. And so think about the Crawford evidence question as an additional evidence rule only for criminal cases. So you have to, there's several inquiries going on here. First thing you have to do is figure out, do you have hearsay? Because if it's hearsay, it's normally excluded. Okay, so let's assume you have hearsay. Let's assume we can't find the wife, or she refuses to testify. We want to use her statements to police. It's hearsay because it's an out-of-court statement brought in to prove the truth of the matter asserted at trial. So it's hearsay. Now we want to get it on because it's hopefully there's an exception to the hearsay rule, and let's use the excited utterance. So we get her when she's really excited, she's crying, she's carrying on, and she says what happened to the police. We want to get that on because the rest of it, once she calmed down, it's probably not an excited utterance, and so it's not going to come in. It's not because it's testimonial, but because it's hearsay. But if it's hearsay that has an excited utterance exception, it would come on against hubby, even if we can't find the wife anymore, or she takes the Fifth Amendment and won't testify. Either way, or maybe she's dead. Either way, we can still bring it on because it's hearsay but has an exception. So, but if we're dealing with a criminal case, we got to throw in one more rule. We got to find out first whether it's hearsay. We've got to find out whether one of the exceptions to the hearsay rule applies when we do have hearsay. And then we have to figure out whether or not the hearsay exception involves Crawford evidence of a testimonial nature before we'll get it on in the criminal case. If it was a civil case, we'd only have to have the hearsay rule. We have to find it's hearsay. We have to have an exception to the hearsay rule. We get the evidence on no matter what in the civil case, not in a criminal case. Okay? All right, the Crawford rule is only applicable when the statements are being used for the truth of the matters asserted in the statement. It has to be real hearsay, not for some other purpose. If you're putting on those statements to prove something else, then it has no effect at all. Crawford does not apply. It only applies to hearsay where there is an exception, and where that exception will be allowing in testimonial kind of evidence. Crawford rule is only applicable if the declarant is not available at the trial for cross-examination. So you can bring on any statement of someone who's there who can be cross-examined no matter what. So Crawford will never prohibit you from using a statement if you have that person there to cross-examine about the statement. Done. Why? Because they have the right to confront, and Crawford's all about confrontation. Also, the defendant's own statements are not applicable to the Crawford rules because it's possible we might have defendant's own statements that are hearsay that we want to use against the defendant, and they may be testimonial in nature, such as a confession. You get somebody in custody, a defendant, you ask him some questions, and he confesses to the crime. That's an out-of-court statement brought in for the truth of the matter asserted. There's an exception because it's a statement against interest. Well, if Crawford applied and the person was not, and we were asking him questions, in order to get a criminal case against him, Crawford would seem to apply. Well, it doesn't. Not for the defendant's own statements. Why? Because the defendant can always get up and testify if he or she wants to. And so there's no loss here by bringing on this evidence, and nor do you have a right to confront yourself. You have a right to confront all the other witnesses against you, not yourself. All right, so is it testimonial or is it non-testimonial? First question, statements of a non-testifying domestic violence victim to first responders or 9/11 operator, those are probably non-testimonial because that person is probably just been beaten up. They are highly emotional. The cops are asking them questions about how to deal with an emergency situation. They got to save usually her from him. So they're trying to get something under control rather than trying to put together a criminal case against somebody. And so that's going to be non-testimonial. What about statements of a non-testifying child sexual assault victim to a family member? This is hearsay, of course, because it's an out-of-court statement. The child obviously saying what happened to them by this family member, or not by the family member, but by somebody. But they're saying it to a family member, so it's an out-of-court statement, and we're not going to have that child testifying. Maybe they're too young to testify, and so you can't confront them because they're not even going to testify at trial. Well, that's hearsay. There's probably there may be an exception to the hearsay rule, possibly. Is that testimonial? It depends. It depends. Most likely it is testimonial because the family member who's asking the questions is trying to figure out what happened so that they can get justice for the family and for the child from the sexual assault. So probably that's testimonial. What about a forensic report by a non-testifying analyst identifying a substance as cocaine? Well, Absolutely, that's testimonial. This forensic report possibly could come in as a business record, maybe, so it may come in, but it's certainly testimonial. Why? Because they're trying to put together, or assisting law enforcement trying to put together a case. They're not there to deal with an emergency situation. So that's definitely testimonial. A written record of an evidence custodian to establish the chain of custody. That's probably not non-testimonial. That means that it is something that it's something that is so routine as to how do we deal with the chain of custody on a piece of evidence, that it's a business type transaction. It's really not a testimonial thing where the evidence custodian is not going to testify about a criminal case or how the criminal case happened and so on. In fact, it's probably not even Crawford type evidence at all. And it's in fact not even testimonial at all or non-testimonial. It's simply someone saying how they handled a piece of evidence in a business record. So that one's not neither, and it's really not affected by Crawford at all. All right, so that's basically the rules. Now let's look at how it actually fits in when we look at this flow diagram that we've already had from the class. Okay, you remember the flow diagram of the analysis of statements for hearsay and its admissibility? Here it is from your work that you have in our module. All right, so the first thing we did was we figured out whether we had hearsay. We went through several parts of the flow diagram to decide whether we had hearsay. If we had hearsay, then we said, okay, is it subject to one of the exceptions? Does it meet one of the exceptions? If it meets one of the exceptions, then we keep going down. If it does not meet one of the exceptions, the statement is inadmissible hearsay. We will not see it no matter what. But if it does meet one of the exceptions, we have to go over a couple of different rules as well. First, we have to ask, is the statement admissible over the hearsay rule? If yes, then is this a criminal case? We have to ask the next question. If the answer is no, it's not a criminal case, then the statement is admissible in a civil suit. However, if it is a criminal case, we have to then go over to this statement about Crawford and see whether it ends up being testimonial Crawford evidence or not. And so we ask ourselves, is the primary purpose of the statement to enable investigation to prove past events? If so, then it is testimonial. If the primary purpose was to enable police assistance to meet an ongoing emergency, then it's non-testimonial. So the question is this statement testimonial in nature? If the answer is no, the statement is admissible in a criminal case. If the answer is yes, it is not admissible in a criminal case. So here's where Crawford comes in to a hearsay exception. So again, we have to first have hearsay. We have to have an exception to the hearsay rule that would ordinarily allow it in to evidence. And we have to have a criminal case. Once we know all those things are true, then we ask ourselves this question, two questions actually. Is the primary purpose of the statement to enable investigation to prove past events? If so, then it's testimonial. If the primary purpose is to enable police assistance to meet an ongoing emergency, it's non-testimonial and therefore admissible. Okay, so that's the rest of the story. That's how you go through this flow diagram to figure out whether something will be excluded in a criminal case because it's Crawford evidence. All right. So that's what we deal with in this one area. We had to go through the law of constitutional rights to see how the exclusionary rule will prohibit evidence that would violate the Fourth Amendment, for instance, but also it'll do the same for evidence that violates the Fifth Amendment. That means say a Miranda violation. And then the Sixth Amendment right to confront witnesses is also excluded if it happens to be testimonial type evidence, but otherwise would have come on if it was a civil case. So this is the way you look at dealing with any dealing with any exception to the hearsay rule that would ordinarily allow on the evidence when you have a criminal case. This part is where you go through the flow diagram to see whether it will be admissible in a criminal case or not over the Crawford rule. Okay. All right. So that's essentially it in terms of where we are on hearsay. We went all the way from the determination of hearsay itself, to exception to the hearsay rule if we do have hearsay, to whether the hearsay exception will will allow the evidence to come on in a criminal case as Crawford evidence or non-Crawford evidence. And that's the end of it. At that point, we're done. There's nothing more to worry about in terms of hearsay. All right, so that's quite a bit of work, and I know it's a little confusing. So again, if you have any questions, please feel free to give me a call.